honor to introduce. It is my honor to introduce Mr. Paninder BN, our chief guest for the day, who is a distinguished expert in forensic sciences and law, holding multiple master's degree in physics, forensic science, cybersecurity, psychology, along with LLB, LLM degrees focused on torts and crimes. With over 14 years of experience, he has examined more than 6,750 cases and provided testimony in over 700 court cases across India, significantly contributing to successful criminal convictions. He is a certified specialist in handwriting analysis, fingerprint examination, accident reconsideration, and digital evidence. His work has garnered international recognition, including the best paper in forensic science awarded at I request everyone to please mute themselves. His work has gained international recognition, including the Best Paper in Forensic Justice awarded at various conferences. As an advocate, Mr. Faninder effectively merges his legal knowledge with forensic expertise to offer critical insights on legal matters. Currently, he serves as a director of Clue 4 Evidence in Forensic Lab in Bengaluru, a court-recognized institution established in 2009 that excels in forensic sciences such as document examination and cyber forensics. Clue 4 Evidence is noted for its high-profile investigation and has earned ICO certification for its professionalism and advanced infrastructure. Under Mr. Fernander's leadership, the lab also plays a crucial role in training law enforcement personnel and legal professions in forensic science. Today, we acknowledge his remarkable contributions to forensic science and law, as he shares his insights on techno-legal aspects of documentary and digital evidence. Now, I would be passing over to Akshita for the introduction of Prime Legal and its founding partners.
Good evening, everyone. I'm excited to introduce the incredible partners who make our firm what it is today. I would first like to introduce our advocate, Ayantika ma'am, who's our managing partner with over 15 plus years of experience in both litigation and non-litigation sectors. I would next like to introduce our advocate Anik sir, who is also our another managing partner, again with over 15 years of experience in both litigation and non-litigation sectors. I would now like to pass it on to Payal.
On the other hand, Online Legal Query, headquartered in Kolkata and guided by Managing Director, respected Ms. Ruma Biswas, along with respected Advocate Anik sir and respected Advocate Anish Palkar sir, who embodies a new change of legal accessibility. Through their innovative platform, they have made legal services not only approachable but inclusive, providing tailored solutions for all, including free consultations. Their mission is to democratize access to justice is both commendable and transformative. Today, we gather to explore techno-legal aspects of documentary and digital evidence, a subject of immense relevance in today's digital era. Our speaker, Mr. Paninder BN, a highly distinguished expert, promises to deliver insightful perspectives that will surely be of great value to all of us. Without further delay, let us proceed to the evening session. Thank you once again for your esteemed presence, and I request everyone to keep themselves on mute while the session is going on so there is no disturbance caused to the speaker. All the queries will be taken towards the end of the session, and meanwhile, you can put in your questions in the chat box and we will further clarify them. The speaker will further clarify them in the F&Q session.
Good evening, everyone. I would like to get a confirmation if my screen and voice is good for further process.
Yes, sir.
Thank you so much. Well, participants have been assigned a responsibility of covering two major topics, which is very close and which is very important for any law professional. Because ultimately, when we discuss about the term forensics, for most of us, we only get to imagine forensics is all about doing the postmortems and what we see in the movies and, CBI, CID serials. While these platforms have given a good exposure about the importance of forensic science in the investigation, but unfortunately, what we see in these movies or the CBI, CID serials is far, from the reality as forensic experts, real time actually get involved in the investigation. Because in the movies, what we see is that anything which is taken to a forensic laboratory gets solved. That is one myth. While in the real time investigations, we have got a lot of such challenges, verticals, and different stakeholders who are involved in collecting a good sample, processing it, document it, examine it, present it before the court. A lot of stakeholders basically for discussing anything about the forensic evidences. In this discussion today, while I have chosen the topic of both documentary and digital evidences, I'll not be touching upon anything about the regular part of our discussion, which means I don't touch upon any signatures or examination, because in this session I'll be taking something exclusive on non-handwriting part of the examination. When I say non-handwriting, it is less often that we have really given such importance on other parts of the documentary evidences, which all only we'll discuss about it. But at this point in time, what is very important for us to understand is the term forensics. Before that, okay, we have to first answer what is a crime. I mean, I don't have to ask this from any advocates here, because while advocates come from the background of defining this as a definition by default, all I want to capture your attention is towards one major aspect. When we keep discussing about the crimes, sometimes we actually identify and designate some categories of crime as a perfect crime. Can someone here unmute your microphone and try explaining to me what do you understand from the term perfect crime? Anyone who wish to unmute and go ahead with the answer? You can even use the chat box to get your responses. I'll look at the chat box.
Hello. Hello, sir. Can I speak?
Please go ahead.
Sir, crime is basically, it is a very wide term. It could be defined as any kind of illegal act that can be punished under the legislation made by any government. And as as far as the perfect crime is concerned, there are some key aspects with regard to crime. There should be punishment for the same. If it is of criminal nature, then the classification, like how serious they are. For example,
But what is perfect crime?
that fits all the elements of the crime. Basically, that has uh, intention, the malified intent, as well as the criminal conduct, and regarding all the elements.
Yeah,
According to me,
that's a perfect crime from an advocate's point of view, which means all the necessary elements to say it is a crime has been fulfilled. Let us also hear from Pratyuksha.
Yes, sir. Good evening, sir.
Yeah.
Sir, crime is an illegal act which is for which the government punishes the accused, and it mainly violates any fundamental right of a person.
What is a perfect crime?
Perfect crime, sir, that is against any law.
Uh-huh. Okay. Are there any other participants who want to answer this question as to what do you term as a perfect crime? Okay. While people are taking the chat box, Okay, perfect crime is such crime which generally is classified as such crimes where there is no evidence left over. Okay, they are committed so perfectly that in usually, the police investigations, at times they use this word, it's a perfect crime. There's no evidence left over. But the question is that, okay, uh, behind any crime, there is always a mastermind behind it. Okay, and we say they have done very good preparation to commit such crime. No footprints, no fingerprints. There is no CCTV trail. There is no any kind of evidence left over. Is what generally considered to be a perfect crime. While we have to understand behind every crime there is a mind. But what is behind every perfect crime? If this question is to be answered, I would preferably say that the term perfect crime itself doesn't exist. Why? Because our criminal jurisprudence says there should be evidence behind every crime. That is jurisprudence. But while we also use the word perfect crime, I would say the criminal has used his best of the mind, but the investigation officer has not used his mind to counter that particular crime. This is when it becomes a perfect crime. Whether if it is inefficiency of the investigating officer, innocence of the investigating officer, or even ignorance of the investigating officer, ultimately we make the criminal win or criminal to take a upper hand by terming it's a perfect crime. Otherwise, in general, it's very wrong to use the term perfect crime. While we have a question to answer on the screen, if to make it very simple for all the audience here to understand what is forensics, the way I would like to explain forensics is that number 4 and number 6 makes it 4 and 6. And we get a derivation or the value as 10. So people would say it's a simple mathematics. What is so special about it? But the aspect of understanding or my presentation is that number 4 and number 6 makes the screen name 1 plus. Please mute yourself. 1 plus, please. All right. While number 4 and number 6 makes the value as 10, the scope of forensics is that
1 plus mute करो वीडियो दिख
okay, participants, we may have to please ensure that our microphones are muted. Thank you. Yes. Well, number 4 and number 6 makes the value as number 10. The question is, in the binary system, we always have this understanding. Number 1 always gives the truth value, or is always considered to be a truth value. 0 is always considered to be a false value. The scope of forensics is to ascertain if the claim is true or the claim is false. And who brings the claim? It is the investigating officer or the court of law or any adjudicating authority who are conducting the investigation would actually bring in that question before the forensic expert. By answering the question is what we ascertain. Yes, if the question is it suppose in a scene of crime they find a red color liquid on the floor, the question is that is this a blood? Yes, by doing the forensic examination we would say yes, this is the blood. Then the next question arises, is this the blood of a human being or a blood of an animal? Again, forensic examination we say this is the blood of a human being. Then question is that is this blood belonging to X person? And forensic examination says yes, it is of X person only. So like that, forensics is all about answering the specific question in affirmation or in negative, depending upon the nature of sample being examined. So this is the primary focus of forensics. But in the digital forensics, the approach of forensics slightly differs, which I'll definitely cover very soon. in digital forensics, we get to gather more data and then decide which of this data is to be considered as an evidence. That's slightly a different approach, but except for the digital forensic domain, in all the other domain of forensics, this is the primary approach where there is one authority which asks the question, and the forensic experts will confirm in affirmative or negative. Now, one of the $1 million question is that whenever you want to take a examination report, okay, participants, please ensure that the microphones are muted. So, fine. So one of the $1 million question before us is to identify how the government labs and private labs are to be considered for the purpose of examination. Well, many of you would say, probably the first question before any court of law, we actually answer the, primary question. Are you a government registered forensic laboratory? Or in the arguments, what we see is that can the report given by a forensic laboratory of private in nature be admissible as an evidence? Let me ask the question to the participants here. Participants, well, most of you come from the legal background. What do you think about this particular question? What is the recognition or admissibility of the private forensic labs report versus the government lab reports? What do you say? Okay, participants, you have to answer this question. Okay, nobody has an answer for this. Okay. Well, we must understand that both of these forensic labs, I mean, private or in government, they are having a lot of similarities than dissimilarities. First of all, let me ask you, when people had to undergo the COVID time, when they fall sick, they want to get some treatments conducted. Tell me, did they go in search of a private doctor or a government doctor? By default, they went to a doctor, isn't it? So the doctor has no difference between a private or government in nature. Similarly, in the practice of the forensics, one has to be professional or properly qualified to act as a forensic expert, provided the person comes from the relevant background of the expertise and the relevant qualification. It doesn't make much difference between a private or a government expert. It is not also true that because you have taken a report from the government laboratory, that expert need not be cross-examined. There is always a scope that the private expert as well as the government expert both are subjected for necessary depositions before the court of law. But yes, in terms of general practices, people would say, it's a government or it's a private, or it's very easy to convince or bribe a private person. It's very easy to get a convenienced approach or convenient report from a private. It's wrong to understand, it's wrong to interpret like this because rats are everywhere. There are bad practices in private laboratories also, and bad practices in government laboratories also. The only question is that which particular case, okay, the person is involved, which person is involving, what are his ethics, what are his professionalism. There are good people in private expert practices also. There are good experts in government lab practices also. So it's not the question about government or private, it's only about ethical or unethical. There are several cases which has been upheld based on the private experts reports or private laboratories report. There are also a good number of cases which is still issued by the government and still dismissed on various grounds. So in this context, it's wrong to discuss about private or government. It is good to discuss about ethical or unethical, professional or unprofessional while discussing about the professional expertise of the forensic expert. But it is also important to know at this point in time, there is no governing body for private or government forensic experts in India. Just like we have Bar Council of India, which governs the practice of both the private public prosecutor as well as the defense counsel. For either of these two people, Bar Council of India is the governing body. Similarly, for Medical Council of India, doctors, first you have to be a member of the Medical Council of India, then you can become a doctor, government, or doctor in private. Chartered accountants, okay, first you have to be a registered chartered accountant practitioner, then you can get into the AG's office or government practices, or you can still practice as a professional in the private practice. Similarly, in the field of forensics, we don't have any such governing body, a council or association at this point in time in India. There are good discussions going on to form a forensic council, but yet, as on the time and date we are discussing this topic, we have nothing as the governing body in India, but we are self-governed as per the best practices in the field of forensic, both internationally and nationally. Now, coming to the specific question of the documents, I'm not touching upon the specific case studies, dear participants. Also by covering certain unexplored topic of our forensic and legal practices. To prove or disprove a documentary evidence or a digital evidence, there are multiple ways. Okay, and in some cases, it also says you also don't require an expert, or the document can be proved by its attestators or by the witnesses. There's a lot of other ways to do that. But before we move on to the documentary evidence and its scope and challenges, Yash Bharadwaj, you have raised the hand. Please let me know what is your query.
Sir, as you have mentioned that there is no regulatory framework as of right now in India for the forensic department. So if any individual or a group of individual wants to open some forensic lab or something like that, there should be any eligibility or the essentials for the same also. So is there any kind of requirements which any private institution have to follow to become a certified forensic?
Okay. While I would like to answer this in candid way, it is the advocate who makes an expert. It is not the expert who became a self-expert. I'll tell you why. When the person calls himself an expert, irrespective of his background, credentials, legalities, whatever, when he produces himself as an evidence before the court of law, it is the duty of that advocate to effectively scrutinize the credentials and credibility of the so-called expert before you move on to the questions on the technical category. It's very unfortunate that the proper cross-examination does not actually while we keep attending cross-examinations, not much of contention on these things are usually taken. I don't know if it is not taken only in my case, or it is a practice of several advocates that they don't even touch upon this thing, which I'm not very sure. But when you look at the cross-examinations of different experts, the qualification and credibility, that's a very important stage of the cross-examination. While there is no regulatory body right now, one has to be proper qualified. When we discuss about the qualification, again, this is a unanswered question in our entire legal dictionary. Nowhere in the law books mentions what is the qualification of an expert. If I have to ask you, Yash Bharadwaj, whom do you consider as an expert? Who is an expert according to you?
Sir, can you please explain in Kannada?
Sir, basically, according to my opinion, and as of that you have shared with me, according to me, an expert would be not relevant to in accordance with law. It is recording in accordance to the field of study which we are discussing. Like if there is some case regarding some DNA confusion, so a doctor who would be expert in that area would be considered as an expert. or if there is a property issue, then a certified maybe property dealer or some kind of uh, work would be there. So expert, according to me, is basically required. All the kinds of work which is included in a case, it is subjective thing. Like what is
No, no,
the
no. See,
fact?
my question is not about whether you require expert or not. Who is a qualified expert? Whom do you
Um,
consider a qualified expert?
who is credible enough to know about the subject matter of the issue?
Okay. In such case, credible enough to know subject matter of issue, I would say attender of a doctor's clinic is an expert, according to your explanation. When people fall sick, when people go to the doctor's clinic, that attender is 20 years experience. He knows better than the doctor what tablet has to be given for what issue. Whereas the doctor can be new. Doctor is just 2 days qualified from the MBBS. Doctor just received a certificate 2 days ago. He opened a clinic. Whereas the compounder or the attender is 20 years experienced.
20 years experience.
Out of these two, whom do you consider the expert?
Expert
So
is
in my
the
opinion,
experienced man.
So you are going to say the compounder is an expert, a compounder, to be treated as a doctor.
Yes.
Think and answer. ಕಪೂರ್ ಅವರೇ ಸ್ವಲ್ಪ ಮೊಬೈಲ್ ನೋಡ್ಕೊಳ್ಳಿ, ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. Yes. So the question is that either of the cases, just because a person is so qualified, okay, so experienced, 20 years of experience, he cannot be termed as an expert because you would say he doesn't have a qualification. Whereas a doctor who recently got qualified, again, you would say, no, he's qualified, but he doesn't have experience. In either of the cases, you are unsure whom do you call an expert. For this reason, the legal context, earlier when we used to have section, 1 plus, ದಯವಿಟ್ಟು ನಿಮ್ಮ ಮೊಬೈಲ್ನ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. Okay. 1 plus, okay, done. So earlier, when we used to have this question of the Indian Evidence Act, there was this provision, okay, section 45 of Indian Evidence Act, which said who is an expert or whose opinion is relevant. They had given an explanation. According to that, it says any person who is skilled in a foreign science or a foreign art is to be considered as an expert. And this talks about the skill and not the education qualification. You must understand this. The same provision as per the BSA, Bharatiya Sakshya Adhiniyam, has now become section 39. Explanation remains the same, only the section has changed. But there are different bodies who certify as experts for different professionals. For this explanation of section 45 or section 39 as per the BSA, it says in the bracket of the explanation, they say handwriting experts and fingerprint experts are to be considered. When they have a skill, they must be considered as experts. This is one such provision. But however, you must understand, not all the cases are to be dealt by a handwriting expert. Let me now show you the case study, and let me also ask you this specific question on the screen. Participants on the screen, you have a specific case where you have one particular content. I'm showing you the rare side of a stamp paper. And in the stamp paper, you have all the necessary entries by the stamp vendor, state treasury, everything. Let me ask you, what do you suspect in this particular document? I know it's a photocopied document, badly photocopied. Still, if you're an advocate, if you get this document in hand, what do you suspect? Is everything fine in this document? What is suspicious? What is not good in this document? I see some chats coming up. Okay. Oh, I have an issue. Signature part is copy pasted from somewhere else. Okay. Anything else? The signature was actually in question in this particular case. That was the reason it was brought to my laboratory. Okay. Apart from signature, anything else anybody suspects here? I know people don't read the script on the screen. The answer is that it is not having any issue with the script. Okay. People don't take a justification. Oh, I don't read Kannada. This Kannada has nothing to do with the case. There is a mark around that part. We have put the bracket because it was the subject matter of examination. Okay. After we have marked it, we have taken the scan. That's not an issue. Anything apart from that? Stamp portion is fake. Maybe I'm not sure. Why do you suspect the stamp part? What is so different? What is so bad in the stamp? Signature were first taken, then contents are drafted. Advocate Vikas has the reason to believe because it's only when signature is already there, the content can be compressed. The person who wrote the document did not know how lengthy the document was. He kept on writing and writing. When he came closer to the signature part of it, then he realizes, oh my God, there are 3-4 lines left over. So he compresses the space between the lines. I do understand, but is it a suspicious factor or a fraudulent factor? That's a suspicious factor. Not all suspicious factors are fraudulent in nature. Okay? Suspicious factor, maybe it's a genuine practice where they don't want to use a second stamp paper. They want to complete in the same paper. There are a good number of cases where the people who drafted, they have compressed the lines to do that. In such case, question to you is that this document is sent to whom for examination? Whom do you send this document for? Would you send this document to a DNA expert? Would you send this document for a fingerprint expert or a digital forensic expert or a handwriting expert? Whom do you send this document to? Handwriting expert. Very good. Question in this case is about the signature, if it is authored by the same person or not. For that reason, you are going to send the document to a handwriting expert. Fine. The handwriting expert in this case was of very limited use. Why? Because I was a handwriting expert in this case. When the client approached me, I said, you don't require a handwriting expert in this case. He asked me why. I can still prove your case for the reason. Now, look at the screen and I have carefully grabbed your attention on the rubber stamp part of it. What is very important in this? The rubber stamp belongs to the state treasury on which the document was set to be sold by the state treasury. This stamp paper gets interned in the hands of a stamp vendor. Look at the document. 9th June 1974 was this paper sold by the state treasury, and this stamp paper is further sold by the stamp vendor to the necessary party on 11th June 1974. Look at the other stamp on this. Fine, a stamp vendor is a private party. He can sell the documents whenever, whichever time, whichever day he can. That's as far as convenience. But in this case, when I examined this document, while I said signature is also forged, but don't take a contention only on the basis of signature. Why? Because this document can be proved fake only because of the rubber stamp in this particular document, because 9th June 1974 is a Sunday. And state treasury have not sold any such stamp papers on a Sunday. This information was obtained by me through a simple RTI. Under RTI, I applied to the state treasury, stamps and registration department, give me all the details of all the transactions which happened on Sunday in the past 50 years. And they respond to me saying that there is no such transaction which happened on any Sunday. 9th June 1974 is a Sunday, and that solves the case. While this, you can actually content saying that this is a facts. This question is about the question of facts in the particular case. So what is the significance of a handwriting expert in this case? I'm still convinced with your question. Let me take you to the next question on the scope of a handwriting expert. Now, participants, on your screen, you have a question. One of the advocate in the same case, while this is a case referred to me from one of the court from Mysore, the question was, if the signature on the top part near the date is forged or not by one particular counsel, they take a difference saying that the top, the signature which is on the date side has been forged. While the other party took a contention, no, it is not forged. This person only wrote the check for so and so on the particular date. He has given the check to us. So both the parties have something to claim in this case. One party is claiming the signature is forged. Other party is claiming that there was a alteration in the particular date. Participants now look at the check and tell me, whom do you send this check to examine? Do you send it to a DNA expert? Do you send it for a ballistic expert? Do you send this for a digital forensic expert, handwriting expert? Whom do you send this document to? It's still going to be a handwriting expert? Oh my God. But tell me, in this particular case, handwriting is not questioned. Maybe apart from the signature I'm referring to, okay, signature definitely has to be sent to a handwriting expert. But apart from signature, there's a question of material alteration in this case. There's an alteration which has been contended in this case. For the examination of the alteration, whom do you engage? Are you still going to engage the handwriting expert? Nothing to do with the handwriting. We must understand, in our entire legal dictionary, there is no word called document experts. It is only referred as handwriting experts. The nomenclature of handwriting expert in Indian context has to be understood. This is the person who is handwriting as well as the document expert. Okay, so the document expert, though it has nothing to, it has not been included in any of our legal dictionary. The subject matter of examination of a handwriting expert also includes non-handwriting part of the documents, which includes pen, paper, ink, typewritten content, handwriting, a printed content, security features of the document. Everything still comes under the jurisdiction, examination scope of a handwriting expert. Now tell me on the screen, is there anything which is fraudulent in this check, dear participants? I'll give you a magnified image as well. You can carefully observe on the date part of it. Unmute your microphone and please answer my question. Is there anything which is suspicious in this document?
The year of the date is overwritten again.
Overwritten. Okay. What is made as what? Can you guess that? Tough to guess. Let me give you the answer. See,
Is the
this check.
5,000 rupees? 5,000 rupees. Seven is before, I think.
Sure, I'll come to that. You have a good observation. Thank you. While the
5,000
date part
only.
of it. Yes.
Date is 2008. This is
Date looks
rewriting.
2008. But what is
Yes,
altered
yes.
to what? ಯಾವ ಅಕ್ಷರನ ಯಾವ ಅಕ್ಷರಕ್ಕೆ ಮ್ಯಾನಿಪುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ?
2003 ಇರ್ಬೋದು ಸರ್. ಅದನ್ನ 2008
Yes.
ಮಾಡಿದ್ದಾರೆ.
Yes. Please understand this check.
Maybe.
Also,
this
also
check.
there is some change in the color of the ink. If we look at the
Exactly.
70 and the 5 and the date previously, which is I guess 2003 or something, and then the 8 and the 7 before the 5,000 ahead.
Very good.
So,
See this check.
Bhagyamma, sir, Bhagyamma also, and 75,000 is different handwriting, and 70 and Bhagyamma looks another handwriting. Other person
Okay.
handwriting.
Good. Good that you are trying to approach this document in multiple different ways. It's good to begin with. However, let me answer what is the facts of this case. This check was disputed of the year 2008, as you see on the screen. Back in 2008, anything which is corrected in the check, if it is attested with a signature next to the correction, it is still a good check. In the recent days, the bankers say no alteration is allowed in the check. That is the recent days practice. But in those days, there was the practice of allowing the altered check if there is a signature. And the forensic examination of this check revealed that there is no forgery in the signature which is done at the date part of it. Signature is not forged. The one who signed Maruti Prasad in the lower part of it also signed the signature at the upper part of it. And this check was initially written as 2003, which is made as 4. You can see a stroke of 4 over there. Because, there was a correction, the person signed some corrections. This same 3 is later on added as 8 at the left side. You can see left part of the 8 is a different ink, as Mr. Yash observed it. Left part of the 8 is with a different ink than the right part of it. While 3 is made as 8 to conclude, they also attempt to make it as the 4. In this particular case, there is both genuine alteration and fraudulent alteration. If you also observe, as participants also observed this, 7 is added later on. Check was only given for 5,000. 7 is separately added. You can question, if that is the case, how did the check got written? The check was only signed, wrote 5,000, put the date, there was a correction, signed it, he gave the check. This Bhagyamma and 75,000 only was not written, and the check was given. It's also not mandatory that such things has to be compulsorily completed by the signatory. Even today, practices are the same. So in that sense, the person, when he received this particular check, added 7, made as numeric 8, and wrote the complete name Bhagyamma and 75,000 only. So this particular examination, if you observe, this is with a technical examination where the ink is so differentiated.
Ink is
under
not
different
differentiated.
Correct.
Yes,
We're using the different light
Yes.
sources. We can differentiate the inks, not the same chemical composition. It is not having the same
Yes.
characteristics. Karke, we differentiate. And red ink, the one which is marked in the red arrow mark is a different ink, and all the other thing is different inks. This is a case
Different.
of involvement of a handwriting expert, but for a non-handwriting case. Look at the screen on the participants. Look at the screen. Now tell me, these 2 documents. And I would strongly suggest that I am discussing certain case with you with only the academic interest of it. Okay? So while these cases are very confidential and very significant for internal discussion only, so you need to understand this is only being shared for the academic and good learning purpose. If you look at the screen, are there anything suspicious in these documents? Okay, I'll show you the magnified image of that. Are there anything which is different in this particular
The
Document?
second one
Yes.
is a
Yes,
dry
sir.
replica of the first one.
Okay, the lower signature, the lowest signature on the screen looks suspicious when compared to the above that. Correct.
Above
I'll
that.
show you the document.
Yes.
Look at the document value right now. It is 9 crores and 7 crores respectively. Each of these documents is to be signed by 2 different officers in the respective bank. While one of the officers, signature is genuine, other officer's signature is fraudulent. And this particular bank took a contention saying that it is a forged document. We cannot honor this particular instrument. While the document is forgery, I mean, signature is forgery, nothing suspicious, I mean, nothing to support that. But in this case, what I did, the receiver bank was my client. If I say the document is fraudulent and the signature is fake, obviously they lose the case. And obviously, I have no interest in anybody winning or losing the case. But my interest is to submit and present the facts of the case the way it is on the document. So I did the examination further to ascertain the rubber stamps of both the officers. If you look at on the left side is a fake signature, on the right side is a genuine signature of the same officer in other documents. Okay, so I examined the rubber stamps and concluded both are the same rubber stamps. Otherwise, people would say, how difficult is it to make a rubber stamp? You can go to any rubber stamp vendor, 30 minutes, 300 rupees. You can get any rubber stamp for that matter. But in this case, while signature is forged, I concluded both the rubber stamps are from the same source. Now tell me, what is the point which you can argue in this case? What does this support now? I advised my client bank to contest this whole case because the rubber stamps are from the same source. The fraud happened inside the bank and not outside the bank. So internally, the bank is now responsible because it is the same rubber stamp which has to be in the custody of the banker, which somebody inside the bank would have misused it. So the fraudster is inside this particular bank. So for that reason, the bank was, taken that liability. So here, the question is not just about the signature verification. It is something beyond signature verification, which only you have to understand. This is a non-handwriting part of examination, which includes rubber stamp, paper, ink, and a lot of other elements. You can look at the document on the screen. While in the same document, in one particular case, we have observed different rubber stamps of the same authority being used in subsequent sheets. The authority's rubber stamp would be same for thousands and thousands of documents. It's very uneven. Okay, that one particular authority's, such rubber stamp is different in different sheets of the same set of documents. And this is again a non-handwriting examination. Okay, you must understand a handwriting expert is not only involved in handwriting cases, but also for non-handwriting cases, but referred to be as a document expert. This is what I wanted to convey from this topic of discussion. Participants, now we are moving to the second part of our discussion, which is on the digital evidences. The digital evidences, wantedly or without your knowledge, we all are badly exposed to the dependency on the digital evidences. Today, almost all the categories of evidences has something to do with the digital platform. Be it WhatsApp data, be it the SMS, call recordings, call data, emails, anything of those things which has to be used as evidence. All those things comes into the digital platform. And the provisions which actually governs these digital evidences are 3 important provisions at this point in time. The first one is, as per today's discussion, it is section 63, subclause 4, subclause C, which was as same as 65B earlier. The only change in this is that the purpose of 65B or the present provision is that it is a authenticity of the data being copied. I have a data in the mobile phone or whichever source. I have used some source to copy the primary data to the pen drive or a particular CD, or I transfer this to a hard disk. When I copy data from one source to another, I must give a certificate. I must give a declaration saying that I had the data here. I have given the data in this particular format, while both the data is the same. Correct. So in the earlier provision, there was a big confusion as to who is the authority who can issue the certificate. Most of the situations, we have seen anybody and everybody issuing 65B certificates. But today, if you look at 63 subclause 4 subclause C certificate provision, they have also given a format on how the certificate has to be. In that certificate, it also mentions who is the authority who is issuing the certificate. So the authority must be a designated officer who can certify this particular data. Ultimately, the specific purpose of this provision is to copy the data. And I keep saying this, there's a bigger threat here. It's not just adequate to certify the copy of the data from one source to another, but there is no legal provision which has mandated the authenticity and credibility of that primary data versus the secondary data. I'll give a small scenario. I have a photograph which is mobbed. This is by one of my friend. I have the photo on my mobile phone. I want to give that photograph in the pen drive to the court. What I will do, I'll prepare a certificate under 63 subclause 4 subclause C saying that this is my mobile phone. I have the data on my mobile phone. I'm copying this onto the computer, my own computer. In turn, I'm copying it on the pen drive. I'm submitting the pen drives before the court. As per the provisions under this section, I have complied with all the necessary provisions. But the question is that, is there any section, any provision which mandates that it has to be authenticated that this file which is on my mobile phone is not manipulated? Are there any such legal provisions? The answer is no. Okay, this section only mentions about how you're going to copy the data, but not the credibility and authenticity of the data on your primary source. The second important provision is that section 39A and section 45A of earlier Indian Evidence Act, which says anyone who is certified or recognized under 79A of Information Technology Act is to be considered as an expert. Section 79A refers to the provision where the central government has to nominate a state authority or a central authority as examiner of electronic evidences. Strictly speaking, the one who is coming under this provision or the radar of 79A is to be considered as the examiner of electronic evidences. But across India, at this point in time, if I'm not wrong, there are only 8 agencies across India who have been nominated as EEE, that is the examiner of electronic evidence under section 79A of Information Technology Act. Participants, the Information Technology Act was enacted in the year 2000. Until the period of 2018, there was no one who was recognized as EEE. For 18 years, there was no one who was nominated as EEE, that is the examiner of electronic evidence. And even today, except for 8 different authorities, fortunately, Bangalore, a CID cell, has been one of the 8 agencies who are nominated as the examiner of electronic evidences. But what is happening with other states? What is the governing part of the reports which are given by every other forensic science laboratories which are not nominated as the examiner of electronic evidence? At this stage, this is a controversial situation. It's not true that only the one who has the EEE certification must issue certificate. But if that is the mandate, Why is that only 8 agencies across India have got this? And what is happening with every other FSL who has not got this? Debatable situation. While coming to the situation of the data on the mobile phones, a lot of such data becomes the evidence before our litigation process. While you all know about all these provisions, let me take you through the important part of it. That is the multimedia evidence. Multimedia evidence, audio, video, images are very, very important categories of the evidences, dear participants. So these things are to be understood where if you have an audio sample, the question before us is, are this audio a manipulated audio or a genuine audio? People would ask us, in any audio sample, there are two questions which is asked. One is this audio genuine? Matlab, are there any multiple audios captured and added together to make it as one audio? That is one primary question. Second question is the speaker identification. Is this person's voice also heard in the questioned audio sample? These two are the primary questions. If you look at the screen on the first clip in the red part of it, if that clip has been edited, I have taken off some small portion of that particular clip to make joining the other clips. We usually do this in the audio editing. If I do like that, in the forensic tools of what we examine, in the second photograph, you can see the red box has a black mark in that. Such black mark indicate that there has been a tamper or there has been a attempt to take off something or add two different clips is what we have to understand from that black marks when we do our forensic examination. While the second question in the audio sample is about the audio speaker identification. Okay, we have to capture the audio samples of the person to compare with the disputed audio, which could be relevant in any of the trap cases conducted by Lokayukta, CBI, or any vigilance officers. These are the people who do this trap cases. Audio has to be proved with the speaker over there. Okay, and this is some cases you can see how we do the examination of the speakers. Okay, and similarly, when it comes to video verification also has the similar approach of the audio. Okay, we have to ascertain if the video has been captured using the video is the result of same capture, or is there a multiple videos joined together to make it look like one particular video. That is one approach. In addition to this, we also verify the audio channel in that. These days we do this Instagram reels and other things. Video is something we can add our audio separately on that. In such case, we do an audio channel examination for the video clipping, which is an additional examination, which can be found out in the forensic examination of the video. If any of the content in the video has been manipulated is what we can examine. That is necessary also. Apart from this, what is very important in the digital examination? People might ask us, using Photoshop, using some other tools online, anybody can create some data. Anybody can create photograph, videograph, something like that. How do we examine that? If such is the case, I would like to grab your attention on my screen. Participants, I'm using a open source tool. You can also go to the Google, okay, and you can search for metadata online. Okay, if you do that, any web application which you get it. Okay, so look at the screen. I am showing you a particular screen for your view. Is my screen visible? The metadata info of your file. Participants, can you please confirm?
Yeah, we can see.
Yes, sir.
Okay. See, this particular file, a portal is only need to be added a particular file from your computer. view metadata. I have loaded a particular file from my computer to see the metadata. Let me choose the file once again. Okay, some document. I'm showing you an open source tool on the screen, but we have the licensed tools which does the similar job. But for a forensic proper examination of the forensics, we don't use the open source tools. No data. Okay. Yes, participants, you can look at the values what I derived. I have got the document scope of services.docs. It's full size document type. Okay, a lot of information about this particular file, which also gives us the time stamping and date stamping. If you look at this,
Excuse me,
yes,
sir. Sorry to interrupt. I
yes,
apologize to you.
please,
We have last 5 minutes of the webinar
yes, yes,
happening. Yeah,
yes,
thank
yes,
you.
yes. Thank you. So you can look at the metadata is the data of the data. Metadata is the data of the data, which actually includes a lot of information of the particular file. This file also will have the paragraph. There are 10 paragraphs in my file. I don't have to open the document. The metadata itself is showing me that particular information. So many number of words, so much number of characters in my file. Okay. So if this is a data of a Word document, .dox. Similarly, when you actually load, okay, any such file, I would want you to do the experiment on your personal computers to understand such data. How much data can we derive from the metadata? If you take a photograph, if that photograph has been edited, how does it look in the metadata? How does the captured photograph would look on the metadata? Do some comparison. And last point before I conclude, any data which you capture on your camera, and when you send on the WhatsApp to a receiver, and the receiver, when he gets the data from the WhatsApp, he cannot use that data as a good evidence. Why? Because WhatsApp will manipulate the metadata. When I say manipulate, WhatsApp creates its own, encryption for the files what we share on the WhatsApp platform. I'm talking about multimedia, image, videos, and photograph. For the same reason, when you receive it, okay, on the WhatsApp, you see clarity is not good. But when you capture on the camera, when you look at it, it's very good. When you transmit on the WhatsApp, it is not so good. The WhatsApp compresses the file and also affects the metadata. One topic which I have not discussed here is the hash value. Please do some groundwork on the term hash value, which you get a good understanding about how the digital evidences can be considered as a reliable evidence. Participants, with this, I'm concluding my part of the discussion. The session is now open for a quick couple of questions before officially we conclude this.
Yes, sir.
Abdul, please go ahead.
Yes, sir. The discussion which we had regarding the 65B, wherein this new BS Act has come. So usually in the courts, we file applications containing some video evidences like images. So if the other opposite party is filing similar application, can I appeal to the court that a forensics expert be appointed, like a private forensic expert?
Yes,
If
yes.
yes,
See,
what is
in
the
your
process I would
case,
like to?
yes, there are two things in this. In some cases, the data is the evidence. In some cases, the device is the evidence. But we recommend that the mobile phone, you see, when you want to take a scope of private forensic laboratories like mine, you can get the video evidence which is in the mobile phone of your client to our laboratory. We extract the video file from the particular captured or source device using forensic tools, which comes with time stamping and date stamping. Give this data to the court need not send the mobile phone again for the examination. video file becomes evidence. We have a report authenticated, which complies with section 63, subclause 4, subclause C, as per the Bharatiya Sakshar Adhiniyam, and similar to 65B certificate. That would be adequate. But in the court proceedings also, you can recommend by the way of application that the mobile phone has to be sent for the examination. But please be cautious when you submit the mobile device itself to the court, unless otherwise you make an application for the mobile phone to be in the safe custody. Because by keeping the phone in the locker, there are cases where the battery has, exploded, phone becomes, dead for different technical reasons. So for that reason, first get the examination, then submit your data.
Thank you, sir.
ನಿಮ್ ಪ್ರಕಾರ ಚಲೋ ಕಾಕ ಇನ್ನ ಯಾವ್ದು ಏನೋ ಕಾಕ
ಸರ್ ನಿಮ್ಮ ಸ್ಕ್ರೀನ್ ಇನ್ನೊಂದ್ಸಲಿ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕಿದೆ, ಕ್ವಶನ್ ಕೇಳಿ ಇನ್ನೊಂದ್ಸಲಿ. Okay, any other participants have any other questions? Okay, I think ಸುಪ್ರಿಯಾ ಗೌಡನು ಯಾರೋ ಒಬ್ರು ಅವಾಗಲೇ ಕನ್ನಡದಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ ಕೇಳಿದ್ರು. Okay, probably I was informed.
No, I just ಇಲ್ಲ ಸರ್, ಎಲ್ಲ ಅರ್ಥ ಆಯ್ತು. Not a issue.
For anyone, ಯಾರಿಗಾದ್ರೂ ನಾನು ಯಾವುದೇ ಹೇಳಿರುವಂತ ಯಾವುದೇ ವಿಚಾರದಲ್ಲಿ ಡೌಟ್ ಸಿಕ್ತು ಅಂತ ಕೇಳಿದ್ರೆ ಪ್ಲೀಸ್ ಕನೆಕ್ಟ್ ಟು ಮೀ ಪರ್ಸನಲಿ ಫಾರ್ ಇಂಟರ್ಪ್ರಿಟಿಂಗ್ ಇನ್ ಕನ್ನಡ. ಇಲ್ಲಿ ಲಾರ್ಜ್ ಆಡಿಯನ್ಸ್ ಕನ್ನಡ ಗೊತ್ತಿಲ್ಲದ್ರಿಂದ ಮತ್ತೆ ಫಸ್ಟ್ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ವಿ ನಾವು, ಯಾವ ಒಂದು ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಈ ಸೆಷನ್ ಮಾಡಬೇಕಿದೆ ಅಂತ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ವಿ ನಾವು. ಆ ಕಾರಣಕ್ಕೋಸ್ಕರ ವಿ ಹ್ಯಾವ್ ಹೆಲ್ಡ್ ದ ಸೆಷನ್ ಇನ್ ದ ಇಂಗ್ಲಿಷ್. ಬಟ್ please come to me personally for any Kannada interpretation. I'll be very happy to help you.
Sure, sir. Thank you, sir.
Thank you.
Sir, if you could enlighten us how to appoint a private forensic expert in the process of court, it will definitely help us.
Okay. So in the process of the court, let me give a differentiation between the private, the civil and criminal proceedings. In the civil proceedings, to appoint a forensic expert comes under the CPC 2610A. Okay, so because the 26 rule 10 talks about appointment of the commissioner, and 10A specifies for scientific investigation. Whether you appoint a government expert or a private expert, that particular provision remains the same. There is no differentiation in that particular clause, that government or private. In the process of Karnataka and in Bangalore especially, Karnataka High Court judgment says that it is a 2016 or 2018 judgment of single judge bench in Dharwad High Court, which mentions in police investigation cases, I am underlining the word, in police investigation cases, the police must strictly take the reports from forensic science laboratory, government forensic science laboratory, if it is a case of signature and handwriting in question. There was one other private laboratory who had given a report, okay, in a particular case, a bad report they had given that went to the appeal. In that particular appeal, court held, there is a possibility if you send it for the private laboratories, they can be manipulating so much. So for that reason, the state government is hereby instructed to always go to the FSL for the handwriting related questions. That is a court ruling. Unfortunately, not that I am disputing over the court judgment. Unfortunately, this is not the right way to look at it. Okay, but it might have different, debatable points to discuss. Not all the private labs are bad, or it would have specifically mentioned on certain particular subjective cases. But there is one provision where the investigation officer, by the application before the magistrate, can request for so and so reason, we are unable to send this sample to the forensic science laboratory government, and this has to be sent to a private expert, okay, for answering these questions. And these questions would include age significance of the ink, which no government labs are doing it today. And private labs, I don't say, not all private labs do that. For this particular topic of discussion, I say I am the one who is doing the age significance of the document. It's not the age of the ink. Age of the ink, nobody does it. I'm talking about age significance of the document. There is a different flavor for this statement. Okay, I would like to answer in the subjective case. So in this sense, with the permission of the DCP, okay, or with the permission of the magistrate, investigation officer can still appoint a private expert for their specific cases, be it be in any domain, they can appoint it. Only for signature cases, they have to take the permission from the DCP and the magistrate. For digital document and any other category, there has been no such restrictions on this.
I have one more question. Could you tell me what are all cities you have presence and how many offices you have? So we have many lawyers from different states, so it will be easy for them to know that you have offices presence and places.
Sure. First of all, Clue for Evidence headquarters in Bangalore, and we are spread across different cities, including Mysore, Hyderabad, and Kochi. Very soon, we'll be having our office in Chennai by the month of January. And we have a work base of around 35-40 scientific category of officers. And most of our services doesn't require a physical presence. Okay, in some cases, we do the examination reporting through online submissions also. All it requires is what nature of case is what we have to discuss. And in the 4 cities, you can approach us by physical presence. In rest of the cities, you can check with us with your specific case, how we can help you. We do have channel partners across different cities across India.
Sir, I do have a question.
Please go ahead.
Sir, can a forensic expert act as an amicus curiae for the court?
Yes, in other sense, as per CPC, the commissioner who gets appointed is nothing but the officer appointed by the court to assist the court. That is the same explanation for the amicus curiae. In most of the cases, amicus curiae comes into the high court practices.
Yes, sir.
But in CPC practices, we discuss about the commissioner to be appointed. But yes, if the matter is before the high court, a forensic expert can also act as an amicus curiae to answer specific question before the high court.
Can he voluntarily act as amicus curiae, or he has to be appointed by the court, sir?
A forensic expert is not an activist. Okay, whereas advocate is an activist. Forensic expert should always wait in his laboratory to get the question. You people have to ask the question, we only answer. We can't be proactive. We can't be activist. We have to be only the forensic scientist.
Okay, sir. Thank you, sir. Thank you.
Thank you, madam. Fine. With this, yes, the last question, we will take it up. Please go ahead.
Okay. So, say for example, I have some digital evidence which I am presenting to the court in form of printouts. It's there on the system or something, and the server is located abroad. How do we procure that meta evidence?
Very good. In fact, this question was also arised in our 2611 case, whereas the prime accused, David Headley, a lot of data was in US servers. Okay, the Indian law enforcement agencies wanted to get the data. For that reason, that was probably the first case where we effectively, did the forensic imaging of the data and got it back to the India to do the further examination. But to the specific question which you have asked, madam, for the same reason, you have to refer to the intermediary guidelines, okay, issued by the Ministry of Electronics and Communication, Information Technology, MIT. That ministry.
MIT recent rules. You are talking about the recent amended intermediary guidelines which came from MIT.
2023, correct. This mandates every such intermediary who hold your data to have a server in India.
Okay.
A broad server to get the data is always challenging. There are situations where the security guards of this so-called aggregator companies, okay, did not allow even DCP ranking officials to enter the premises with a warrant, because they say our company policies doesn't allow this data sharing. Yesterday or day before, one police enforcement officers have lodged a complaint against WhatsApp for denying data to be shared for investigation purpose. First of its kind case against WhatsApp. Just check out today or yesterday, I read the news. Okay. And these companies are now mandated to respond to the requests of the law enforcement agencies within 15 days of the request. They are obligated to share the data in the interest of the national security and for the investigation requirement. And in that sense, the companies are obligated to have the data in India, but any servers, outside
They do
India,
not have the
we have no
metadata.
provision to. Come
What
again?
what if they do not have the metadata?
See, every file will have metadata. Okay. The only possibility where metadata is not there, if it is processed through our Telegram or WhatsApp kind of platforms, where this actually compresses in the process of transmission. And that is the evidence that it is not the source file. When metadata is not there, that is evidence it is not the source file. But any source file would have the metadata to be read by any open source tool. Also, the forensic tools what we use it in the regular process of investigation.
Okay. Yes, that kind of answers my query.
Yeah, we
I
can.
know it is not answering your query completely, though. Definitely, this is a very vast question to make you understand in that specific question and answer topic of it. But you can directly correct to me to continue with your clarification on this. Thank you.
Thank you so much, sir.
Yes, sir.
Definitely.
I'm going ahead with the last question. It's not
Yes, sir.
purely legal. We wanted to know more about proof for evidence.
Okay.
So what is it? Service?
Your organization, sir.
Yeah, for the organization. We want to know, so anybody are interested, how they should reach out to you.
Okay. So Clue for Evidence as an organization, we are today have completed over 15 years of our operations. We are a private limited company. Okay. As a private limited company, we also have necessary ISO certification, which is the industry standards. Okay, because we don't have a governing body, as I mentioned before. We regulate ourselves in the utmost possibilities of keeping our professionalism and industry practices high. Proof for Evidence is now a parallel forensic science laboratory. And for approaching Clue for Evidence, you don't have to have a limitation where it has to be a police complaint or a court complaint. Okay, we are open for answering any such cases, any such queries, which can be directly approached by any client, any advocate. You can check with us what is the veracity of your evidences and prepare your case accordingly. And let me also give a caution notice. Clue for Evidence, as a private forensic science laboratory, is known for its integrity. And there are certain cases where people approach us because they want a favorable report. Okay, we don't have the practice of acting as tilers. When I say tilers, we don't customize our reports as per your requirement. We only give our report. It might or might not favor you, but yet we charge you because we conduct the examination with no promise to whom the report is in favor of. There are n number of clients who come to our office, they pay the entire amount, they start debating with us. Oh, we have paid the money, the report is against us. I can't do anything. So we can only be approached to know the facts of your case. Without any promise, the reports will be in your favor. We cover document, fingerprints, digital, and field investigations like theft cases. We do the crimes investigation. We do the accident reconstruction cases. This is very much required for your MSCT, insurance cases to fix the negligence, contributory negligence, other aspects. In fire cases, it requires to ascertain what is the cause of the fire or to defend that there was no negligence for a fire, inevitable accident. Okay, for doing this, it requires a forensic approach. We also do the polygraph test for the corporates. For those who are the advisors for the corporates, we conduct the interviews, we conduct the loyalty tests based on the polygraph, results. So this is where Clue for Evidence acts as a forensic lab, also as a professional investigation company. So as a individual, I come from techno-legal background. I have also read my academic qualification. So I'll be very happy to help individuals or any businesses to secure your legitimate interest in any given situation.
I have another question, sorry, that I'm just extending. As we know that you are also advocate and been enrolled. And can anybody hire you to cross-examine any part of the evidence for the forensic issues?
So while people categorize themselves as civil advocate, criminal advocate, family advocates, so I like to consider myself as a forensic advocate, where my limitation as an advocacy practice is only for this stage, where I'll be consulted to cross-examine a technical witness, to appreciate a good evidence and nullify a bad evidence before any adjudicating authority. So my role only limits to this particular role. I don't practice end to end, but I help any advocate who wants my service at a given specific stage of the case. Sure. Thank you.
Thank you. Akshita, over to you.
Hello, everyone. I think it was a nice, engaging session for everyone. So I'm coming to the part of Thanksgiving. So on behalf of Prime Legal and OLQ, I would first like to thank Pahinder sir for joining us in this webinar and sharing your view on techno-legal aspects of documentary and digital evidence. Your insights were incredibly informative and greatly appreciated. We are grateful for the time and effort you put into delivering such an engaging session. So next, I would like to extend the Thanksgiving to our managing partners, Advocate Ayantika ma'am and Advocate Anik sir, and then all the other participants as well. Before we end the session, I would want to inform everyone that the same has been streamed on Prime Legal's YouTube channels and as well as on Online Legal Query. It will be great and helpful if you all can like, share, and subscribe. Yeah, thank you, everyone. Thank you, everyone.
Thank you.